Okie dokie. Hi, everybody. Welcome. My name is Bianca Beck. I am the Middle East Marketing Manager at Sovereign PPG. I wanted to thank you all so much for joining us today for our live Q&A session, answering all of your questions about HR, labor, and immigration matters for your businesses here in the UAE. I just need to let you know a couple of house rules. The session will be recorded, so that means that we will be able to share the recording with you afterwards and also circulate the presentation. We're joined by two speakers today. We've got our Head of Operations, Libbie Burtinshaw, and our HR consultant, Faraz Ahmed, who are going to be speaking to you in just a moment. We received a huge amount of questions ahead of the session, which was great, and we have done our absolute best to combine and address as many of these questions as possible, while still leaving time towards the end of the session to kind of open the floor to anybody's questions here online today. A real variation. So we really were presented with some common themes in the questions that you asked, and I think the majority tended to be around visas, dependents, termination. There was quite a few on compensation and gratuity, as well as WPS and generally the employee onboarding process. So just to let you know that the Q&A function is now open. So if you have any additional questions that we do not cover and that you'd like us to address, please submit them in the Q&A section, and we have a dedicated time for this at the end. So I'm going to hand over to Libbie to answer some of our Libbie and Faraz, but Libbie, one of your questions is up first.
Hi, good morning, everyone. So a popular question we have received is, can I transfer my visa to another company if it's for the same jurisdiction? And the simple answer is there are no transfers currently in the UAE. It would be a full cancellation and reapplication. But it is possible if you are moving within the same emirate. So, for example, your initial visa was issued in Abu Dhabi and you were moving to another Abu Dhabi visa, you could place any family or dependents on hold with the immigration department whilst this process is ongoing. They would need to be inside of the UAE whilst that is happening, but they can stay on hold for up to 60 days until your new visa has been issued. And then as soon as your new visa is issued, their visas continue under the same validity as they were previously. So you cannot transfer, but you can cancel and reapply.
Good morning, everyone. One of the more common questions we have around employee side is, when do I need to cancel an employee's visa once they have left the business, and whether you can actually keep that visa active until they secure new employment. I'm sure this is quite a popular theme that many of you have come across, but it's very straightforward in the law. You should be cancelling visas on their last working day immediately. This is because the ministry is very strict when imposing fines, and these fines can range from 100,000 dirhams to up to 1 million dirhams for false employment when they have no active employment necessarily. So it's very important to know that even if it is someone that you are trying to do them a favor, your best option in terms of staying compliant by law is to cancel a visa immediately upon the last working day.
And this one's a bit of labour and immigration and a bit of HR. So we are going to cover this as a dual answer. So an employee can start legally working for the company once their work permit is issued. And from the HR side of things, that is once they have their active health insurance. As we all know, health insurance is mandatory for all your employees, and usually that comes towards the end of the process, and that can delay the rest of the visa process. But we fully recommend to be legally compliant that it is once the work permit is issued and the health insurance is activated.
Yeah, I mean, that's covered pretty much everything, Libbie, actually. So superstar, weren't they? Okay, what is WPS and who does it affect? Again, this is one of those very common themes that you see in this country. WPS is the wage protection system, which affects all mainland companies and specific free zones such as DMCC and JAFTA. It's essentially a safeguard for the ministry to make sure employees are being paid their salaries, A, on time, and B, in line with what is mentioned in their employment contracts. The WPS system also monitors salary reductions. So it's important to know that on any given month, you cannot deduct more than 10% of their total salary when doing it through WPS. The purpose of WPS is to make sure that it's a safeguard for the employees. So it's an incredibly important thing to consider, and failure to be compliant with WPS can result in fines, both of value as well as operational fines. You can have blocks on your work permit applications, your WPS system can get blocked, so it's very important to stay very compliant with WPS. Okay, when will WPS start for a new hired employee? Is it when the work permit is approved or once the labour card is issued? The answer is when the work permit is issued. In essence, most of all companies that are WPS compliant, when you have a new joiner, you do have a 30-day grace period. And this is because we know that sometimes it can be a bit of delay between getting the work permit and labour card, getting the MSID. If it's a new person in the country, there might be some slight delays with that employee setting up their UAE bank account. So you do have a 30-day WPS kind of grace period or a leeway period, but it's on the issuance of the work permit.
So moving on to employees and attested degrees. So as many of us will be familiar with, designations will require certain levels of education certification. And for mainland companies in particular, any certificate required for a designation will need to be attested. In some free zones, they're a little bit more lenient, but we would say a rule of thumb is that any employee holding an education certificate would have this attested so that they would benefit from a higher designation in their visa, work permit, and labour cards. This also benefits the company. We have seen previously in the past, in terms of diversity and skilled and unskilled workers, that they do enforce restrictions on the number of unskilled workers that you have under a company. Having skilled workers is beneficial to the company, not only in terms of new hires and labour quota, and it's more attractive for your employees, but it also will change the category of the company. So the more skilled workers you have, the higher the category of the company, which can give benefits in terms of tendering for government contracts. So our recommendation is if your employee does have an education degree, an education certificate, that getting that attested should be a priority, and that will benefit you as the employer as well. So is the company responsible for family health insurance of employees in Abu Dhabi? And simple answer, yes. It is mandatory in both Dubai and Abu Dhabi for you to provide insurance for your employee. In Abu Dhabi, it does work slightly different. The employer is also mandatorily required to provide insurance for the employee, the spouse, and up to 3 children up to the age of 18, which does differ from Dubai. So yes, you do need to give your employees insurance.
I think one of the ones, like we said, termination is a very popular topic. Can an employee be terminated during their probation period without notice? The answer there is yes, they can be terminated without notice, but a termination should always follow a notice period, especially in the probation. It can be different to what it would be out of probation. And the answer there also lies in terms of you don't have to necessarily give cause when terminating someone during the probation period, as you would supposedly do with outside of notice period, but a notice period is required.
So going back to WPS blocks, again, very popular. So if your company has a WPS block, that can mean that you will be prevented from applying any new labour cards, any new work permits, any new labour quota. Your company could also find themselves fined. So it is a requirement for you to make sure that you are renewing on time your employees' labour cards. You do have 60 days from the expiry of a labour card in which to proceed with the renewal, or that could block you. As Faraz covered previously, WPS, there is a window of 30 days from the issuance of the labour card in which to pay your new hires through WPS. If for any reason you did get a WPS block, it usually is rule of thumb by Mori that you have to repay any missed salaries, and this needs to be proven to Mori by bank transfers, receipts, acknowledgements. It can be fixed relatively simply. Sometimes it can be just down to there was an error with the SIF file and it wasn't returned at the time of submission. We can help remove WPS blocks. We can also ascertain why you have your WPS block. Sometimes it is simple. It will depend how long that WPS block has been in place to how severe the repercussions are. But we have seen companies that have many months of WPS block manage to have that resolved without fines against the company. So there is always light at the end of the tunnel. If you do think that that is something that is insurmountable, that is something that we can definitely advise and assist on.
Yeah, so the next one here is I'm terminating one of my employees. What are the necessary steps to be mindful of? So the first question that should always come up is what is the reason for the termination? In the UAE, terminations cannot be arbitrary. They need to follow a cause. Cause can be misconduct, which if you are terminated for misconduct, you should at least provide evidence that you have conducted an internal investigation. You have informed the employee that this investigation has been taking place. You have issued warning letters, and you need to make sure all of this documentation is there, because this will help you in the instance that the employee might file a case for wrongful termination. The same would go for performance. If it's an underperforming employee and you wish to terminate them, then you do have that opportunity of putting them on a performance improvement plan, with the action being that if they don't meet the standards during that performance improvement plan period, then it could result in a termination. Now, there are very specific situations under Article 44 of the UAE labour law where you can terminate an employee without cause. But again, those require an internal investigation to have taken place, and that internal investigation to have been done so in writing. Okay. How are unused leave procedures if there is no internal policy or if they're not able to use the leaves due to work obligations? So by law, the law states that a worker can carry over no more than half of their annual leave the following year. But there's also a distinction there. So the distinction being that if for any reason that the worker is not able to take leaves due to their obligation, there is a threshold that they can carry over up to 2 years of their leaves in full, or they can take cash in lieu entitlement for those leaves. Do you need to provide a lunch break for employees that work a 9-hour day? The simple answer is yes. It doesn't have to necessarily be a lunch break. What is mentioned in the law is that every 5 consecutive hours worked should be followed by a 1-hour break. Now, this break can be for going down and getting a snack, can be for prayer breaks, can just be recreational if required. It doesn't necessarily have to be defined as a lunch break.
So we did cover this briefly in the transfer question. So I have dependents sponsored under my visa and I'm moving my visa into our new entity. How does it affect my family visa? So if you are moving to a new visa within the same emirate, then the family would need to be placed on hold with immigration. Once they're placed on hold, you would then proceed with your current visa cancellation and new visa application. And once your new visa has been issued, then your family visas will be reinstated in immigration and continue the same validity as was previously issued. If you are doing the family on hold process, they do need to be inside of the country, and you also need to be inside of the country, and you must all remain inside of the country during that process. Family on hold is for 60 days, and there is a deposit that is paid to immigration for that family to be placed on hold, which is then refunded at the time of your new visa being issued. So you do have a 60-day window to do that. If you are moving from a Dubai visa to an Abu Dhabi visa or a Sharjah visa to a Dubai visa, then you would not be able to place your family on hold with immigration. You would need to cancel your family before your visa is then cancelled, apply your new visa under the new entity, and once your new Emirates ID has been issued under your new visa, then you can reapply for your family. So there's 2 options there. It will depend on your personal situation, where you are moving to. But if you do have any further questions on that, we would be happy to do consultations.
Yeah, does the UAE labour law provide any guidance for overtime compensation? Yes, overtime is there in the UAE labour law, and it's considered as any work that would exceed the contractual hours and does not exceed more than 2 hours per day. So there is a little bit of leeway that's sometimes given in the law, which says that it's 8 hours per day or a maximum of 48 hours per week. If anything exceeds that amount, then the overtime would kick in. Now, overtime is calculated in 2 separate ways. The first is if it's overtime after work hours, it will be calculated at the employee is entitled to their base hourly pay rate plus 25% of that hourly pay rate. If the work conducted is between the hours of 10 p.m. and 4 a.m., that overtime compensation exceeds by 50%. So that would mean, for example, if my hourly rate was 100 dirhams, I would be entitled to 150 dirhams per hour worked as an overtime calculation. Okay, is it fair to not pay overtime during busy project periods because the team had 2 to 3 months? Okay, so this is a bit more of a specific question here. Had 2 to 3 months of no work before mobilization, or should we pay them overtime regardless of earlier idle time? It's very straightforward here, especially for contract or project staff. In the periods of downtime where they're not working, they should be placed on an unpaid leave for that period. And then when they are working, and if they're exceeding their working hours, then you should still be paying them overtime to make sure that you're compliant. Now, there is an application through Mahri that you can do for a period of unpaid leave. But this would be the most compliant and most accurate way. You can't withdraw the overtime entitlement that this employee would have just purely for the fact that they were not working at a previous time. Okay, one of the most popular questions in the country, is there a percentage split for basic salary versus the other allowances? The straight answer is no. There are a lot of companies that will do it based on certain rates or certain percentages, but general best practice in this country would be to be 60% of the total monthly salary towards basic salary, and the remaining 40% be through towards the other allowances. I think Bianca has also put up a poll in the chat feature, so it's something for you guys to answer. We would love to hear what you guys do for your practices internally.
It's probably also worth mentioning here that basic salary will affect the end of service gratuity as well, which is why some companies do tend to do the 60-30-10 or 60-40 split between basic and other allowances. But obviously you can put 100% as the basic, it will then affect the gratuity. Okay, so we have quite a lot of interest in remote workers and remote working visas. So this question is quite interesting. Can we issue UAE full-time or part-time contracts to remote employees based abroad, or do they need local contracts in their country, especially where that company has no legal presence? So there is in the UAE a remote workers visa, and that is based on that employee coming to the UAE and working remotely for an entity that is outside of the UAE. So that the company would then give no objection for that employee to live in the UAE and work for them elsewhere. The other way around, we don't really touch on that. So, for example, if you had workers that were outside of the UAE working for a UAE-based company, it will depend on where they are living and maybe the tax implications of where they are living. And but we would say if you have a legal presence in the UAE, any of your employees should be sponsored and contracted under that UAE entity, especially if they are here. That is the legal minimum. If you have an employee that is working from the UAE and you do not have a legal presence in the UAE and they are working for a company outside of the UAE, that is the remote working visa option.
Yep. This is a really interesting one that's come in. Actually, it's can a company legally deduct visa costs from an employee's final salary in the UAE if the contract mentions that possible repayment upon termination, especially during the probation period, can be put on the employee? The simple answer is no. It is illegal for an employer to recuperate the costs of recruitment from the employee if they wish to resign during their probation period. Recruitment costs would cover your visa costs, any other recruitment costs if you've hired them through an agency, for example, including their labour and immigration expenses. Now, what an employer can recuperate from an employee, especially if they are leaving during their probation period, is training costs. So for very specific roles where they might have had to have some kind of qualification, certification, training to be able to do the job, in those instances, you can recuperate those training costs. But the very simple answer is you cannot recuperate visa, immigration, or even recruitment costs. In the market contract, you can only show fixed compensation and the other fixed allowances. what's the best way to treat performance-based or sales quota-based variables? The very simple answer here is to have an internal employment contract, or what we call a sale and commercial commission agreement. The reason for this being that your internal employment contract should be a lot more detailed than the one that you get from Mockery. It will cover a lot of other things. This can include discretionary bonuses. This can include sales commission structures, what the payment options for those are, how often those are paid. Some people can have an annual bonus, a quarterly bonus, some can have quarterly sales commission, etc. So it's an important aspect to have an internal employment contract that can address a lot of these details that the standardized Mockery contract would not do.
Okay. How long can I stay outside the UAE on my visa without it being cancelled? So previously it was a flat 6 months. If you were outside for more than 6 months, your visa would be automatically cancelled in the immigration system, and you would then have to reapply a new visa. We now have short-term and long-term visas. So we have the standard 2-year employment visa or spouse visa. And we also have the golden visas, which can be 5 or 10 years, depending on the category. So for an employee visa that is 2 years, they can stay outside no more than 6 months. And we would recommend that it's not more than 179 days consecutively, because there is a grey area whether on that 180th day it is into the cancellation or if it's the 181st. For golden visa holders, it is 1 year, so they can remain outside of the UAE for 1 year. But we have seen recently that there is a re-entry application. So it is possible, if you have surpassed your maximum allowance to be outside of the UAE, that it is possible to apply through immigration for your re-entry. So you would submit to immigration supporting documents that prove why it was necessary for you to remain outside more than the allotted time. And then that is submitted through immigration, and they will either approve or reject it. Most commonly, they are approving it because they do want you to come back. And you are then able to re-enter as normal. Nothing happens to your visa. It just continues on the same validity. We are able to assist with that, and we have successfully done it a number of times in recent months. We would recommend that if you are unsure, there are ways for us to check if your visa is active in the system or how long you have been outside. So please do reach out if this is something that you require help with.
Is it mandatory to provide an offer letter to your employees, and is it different to an employment contract? Again, we advise always to have an offer letter presented to an employee, because this process, especially when it's an internal offer letter, will be before you even start the visa and immigration process. And it's important for you to lay out the terms of that employment that will happen once they do accept the offer. An important thing as well that we like to say in your offer letter is to have a caveat which gives you a little bit of protection. That is that the offer is subject to reference checks, background checks, police clearance forms. Again, it's just a bit of added layer of protection for you to make sure that both parties are on the same page when it comes to the terms of employment, salary structures, holidays, leave allowances, etc. Okay, going back to the offer letter again, what are the main components that should be included in the offer letter? So the main components, or the core components you should have there at the very minimum, is the role or the position that this employee will be taking on, when this role is expected to start, the full breakdown of the remuneration that they expect. So this would be the total monthly salary broken down into the basic allowances, the amount of annual leave this employee would be entitled to, any benefits. So benefits can be, besides the mandatory medical health insurance, it can be a flight allowance if you're providing a flight allowance. It could be a discretionary bonus, whatever it may be. And then the probation period and notice period should be very clearly identified. I know we don't really have a direct question on this, but in the UAE, a probation period maximum by law can be 6 months, and that cannot be extendable. And a notice period by maximum can be for 90 days, which is 3 months.
This was a little bit of both again. I'm going to try not to step on Faraz's toes. Faraz, do you want to go first?
Yeah, okay. So is it mandatory to update a labour contract when an employee's salary is increased or is changed? For mainland companies and also the ones that are based in the free zone, yes. For the mainland side, it's important, especially because of the WPS compliance. If the WPS system is noticing that the salary being paid to the employee is different to what the salary was on the outdated employment contract, this will raise red flags for them, and this can cause blocks. And the same applies for free zones, especially when it comes to employees wanting to apply for a loan or a credit card with their banks. Free zones would need to issue a salary certificate through their portal, which should have the updated reflected salary. Sorry, Libby, I've
fine.
basically looking over for myself.
I've still got things to add, so don't worry. As Faraz said, it's recommended and very much mandatory to update labour contracts when salaries change. One of the prime things that we've seen recently is when people are trying to apply for golden visas under the skilled category, if their basic salary doesn't reach the criteria, however, for the previous 6 months, they had been paid that because their salary had been increased and they'd agreed it internally, but their contract didn't reflect that. That then causes issues. We very much recommend for the safety of the employee and the employer that you do make any amendments to contracts as soon as they happen so that nothing can be held against you or could go wrong. For example, you wouldn't want to have an issue with an employee going to labour to say that actually I had my salary increased at this time and now I'm not getting the end of service benefit based on that as well. So we do recommend any change, whether it's up or whether it's down, is done as soon as that is reflected internally.
Okay, moving on to something along the lines of amortization. This is a topic that has had a lot of confusion because of the fact that there are two distinctions between amortization. I have only 23 employees. Does amortization apply to us? The answer is yes. Amortization applies to any company in the mainland that is over 20 employees. The requirement there is if you are a company with 20 to 49 employees, you must have hired one employee by December of 2024 and a further one employee by December of 2025. Now, again, like I said, there's a distinction. So there's the 20 to 49 employee category, and then there are the ones that have 50 plus employees. For 50 plus employees, it's slightly different. They need to achieve by the end of this year a total of 8% of their workforce or skilled workforce being Emirati nationals. There are two deadlines for the 50 plus category. The first deadline being end of June, where they need to increase their total Emiratis by 1%, and the other deadline being the end of December, where they have to again increase by 1% for a total of 8% Emiratis representation in the workforce. Okay, what are the mandatory benefits that must be provided to all employees under the labour law? So for mandatory benefits, it's obviously the first thing would be an employment visa or a work permit for golden visa holders. Um, the next one would be a medical health insurance. This is a mandatory step for all employees across the entire country, regardless of if you're mainland or free zone. Every free zone and every mainland company does need to mandatorily provide health insurance. End of service gratuity is another entitlement that employees have. This is only really applicable if the employee has completed 1 year of service with the company. And it's slightly different for those that are registered in DIFC. DIFC does not have end of service gratuity. They've got their own in-house system called the dues portal. And a repatriation ticket that should be provided on termination if the employee is no longer going to stay in the UAE. There are other benefits that you can provide, and Bianca has just opened a poll to see what you guys provide as enhanced benefits. But this is the limitation in terms of statutory requirements.
Okay, another golden visa question. Do I need a work permit if I hold a golden visa? Yes, if you are working in the UAE for a company and you hold a golden visa, you should obtain a work permit labour card under that company that you are working for. That is for as much for your safety as for the employer. It would be issued with the jurisdiction in which you're working, so whether that's a free zone or whether that is mainland and with mooring. So yes, you do need a work permit if you hold a golden visa and are working in the UAE. This is another dual one. I'll go first and I won't take over, I promise. So if you do have a GCC national working for you in the UAE, the first thing that they will need is an Emirates ID and a work permit. That is the basics. And then from a HR perspective, I'll pass over to Faraz for what is required.
Yeah, thank you, Libby. So from a HR perspective, it's very important to know that all GCC nationals must be registered under the GIPSA portal. So it's the same portal that regulates mainland Dubai entities from registering their local Emirati nationals. GCC nationals across every single emirate working in Dubai need to be registered with GIPSA. So those are the kind of two or three key components you need to know with GCC nationals. Hey, what is the end of service gratuity and who is eligible to receive it? So end of service gratuity in this country is provided to everyone. That can be full-time, part-time, project workers, or even domestic workers that have completed at least 1 year of continuous service. The calculations for end of service gratuity are very simply from year one. If someone has worked more than 1 year but less than 5 years, they are entitled to 21 days of basic salary for each year between those first to fifth year, and 30 days of basic salary for everyone that goes beyond the fifth year. Now, I've seen a couple questions on the chat feature about this, so I just want to highlight this. In the UAE, end of service gratuity, employees are eligible to it regardless of the means of termination. So regardless of if they have resigned, if they were terminated, without cause, without notice, regardless of the means of termination, an employee is still entitled to their end of service gratuity. And the limit on that is up to 2 years of the employee's wages.
Okay, so that was all of our kind of pre-asked questions. We've received some other questions that I'll read out to you guys to try and answer. We'll try to get through as many as possible. We've got another 20 minutes or so.
Yeah.
So, there was a question here about nationalities not being being able to receive work permits. Is there, I think it's got to do with the quota and 20% thing that we saw recently with some nationalities having some issues with receiving work permits. Is there a list, is there a distinguished list about nationalities and how the quota is calculated?
I actually saw this question and I read it quite differently from you, Bianca.
Oh, sorry. Okay.
That's fine. So there are some nationalities that are restricted from obtaining work permits. It is constantly evolving. There is no published list. For obvious reasons, I don't think the UAE would want to come under fire for publicizing anything that could be deemed as discriminatory, but we can advise on a case-by-case basis at that specific time what we are seeing difficulties with. As Bianca mentioned, there was diversity where there were certain nationalities, if you already had a high percentage of that nationality, that they were then preventing further applications until you had deviated from that nationality. I would be uncomfortable saying right now exactly which ones are blocked, but I will be happy to do that in private.
Kay was asking, is there a difference between Abu Dhabi and Dubai visa processing?
Yes. Yes, there are differences in the processes for how the application progresses. But I also saw that Kay has asked if there's a difference between the UAE labour law, and no, there's not on that. That is federal. So the UAE labour law is the same across the UAE.
Okay, Rajesh was asking if a single employee can have a dual employee contract for the free zone and mainland.
So there are, so how it would work, the employee would be visaed under one entity and then would have maybe a part-time contract or a temporary work permit or a secondary contract with another company. So if they're working for two companies at the same time, they should have work permits for both and a visa under one or the other, or if they're sponsored under a golden visa or a dependent or a spouse.
Yeah,
Okay.
and just a quick one on top of that. So in that situation, the sponsoring entity should provide an NOC as well for that employee to be able to work in the other company on a part-time basis or a contract basis.
Donna's asking here, is it statutory to include an annual flight home for an Abu Dhabi-based employee visa? And
No.
is there
The
limits? Oh, sorry.
Sorry.
Just the second part to that question, is there a limit to cost of flight?
So it's not a mandatory benefit, as Faraz covered in his section. It could be an additional benefit that your company would like to offer, and if you do offer it as an additional benefit, then yes, you are within your right to limit it based on the average flight to country of origin. But no, it's not statutory.
The only thing statutory would be a repatriation ticket if that employee is terminated and they are no longer going to stay in the UAE upon termination.
Okay. Abdul Hamid was asking about, am I able to remove an employee from a company visa if he did not sign the final settlement letter?
If the final settlement letter is not being signed, but you have paid all your dues, then the best suggestion I would make is to speak with Mockery, raise this with them, because without the employee signing the final settlement letter, your visa cancellation won't go through. So I would suggest have a word with Mockery, raise all the facts, make sure that the final settlement is paid out accordingly to what the employee's entitlements are, and then you can take it from there with Mockery.
Okay, Anna's asking here, does an employer require an NOC from their employer to work for their own company that they've set up?
It depends when they're setting up that company. So usually if you're setting up a company whilst you're already under the sponsorship of another company and your visa is under that other company, then the jurisdiction that you're setting up a company with would ask for approval from the sponsoring entity in order to do that setup. If you've done it before, if you already set that company up before you go and work for somebody, then that's on you to give visibility on your secondary hustle, I guess.
Okay, great. Joni's asking here about salary increments. Is it mandatory to then update this into the basic salary, or can it be added to housing and other allowances?
Again, that's entirely up to you. Like we said, best practice in this country is 60-40. So if the salary is increasing, it should really, as a best practice, reflect both the basic increment and the allowances increment.
Okay, Gemma asked a question here. It's a little bit of a longer one. Regarding the work shift of 12 hours for 4 days, 4 days of work a week with 3 days off. What would the calculation of break time be? Additionally, if you could please clarify whether overtime will be applicable in this scenario, considering we are calculating the total number of hours based on a 48-hour week.
So because of the fact that you're not breaking the 14 hours, I don't believe that overtime would need to kick in. But with break time, it's very straightforward. It is an hour break for every 5 hours of continuous work, in which this case it would apply that you would need at least 2 breaks for the 12-hour duration.
Okay, Kay, you've already covered this one, Libby, from Kay again about UAE employment law differing from Abu Dhabi and Dubai. George was asking a question about annual leave based on internal contract is 21 working days. However, the contract from DMCC is 30 days. Does this make a difference?
Yeah, so the way that the mainland all the free zones mentioned leaves in this country are calendar days. So when DMCC says it's 30 calendar days, it would actually translate to 22 working days. So it would be the same there, whether it was 22 working days or 30 calendar days.
Okay. Joel's asking here about golden visas, whether they renew automatically.
They do not. When it gets to the end of the validity, there would need to be an actual renewal application. Unless that changes, obviously, in the next 8 to 9 years, but we'll see when we get to the end of the first tranche of 10-year visas.
April is asking, what will be the gratuity or final settlement calculation for immediate termination for an employee who worked 12 years? Does it work out to be 3 months of total salary?
No. So for again, with it being an immediate termination, the reason for termination doesn't matter. In this case, it would be 21 days of their basic salary for the first 5 years, and then it would be 30 days of basic salary for every year afterwards. So 21 days of their basic salary multiplied by 5, and then it will be 30 days of their basic salary for all those years afterwards.
Okay. Dali was asking, what is the minimum salary requirement for an executive director to secure a golden visa?
Okay, so for a golden visa under the skilled category, which would be a director, the minimum basic salary is 30,000 dirhams per month. They would also need to have been under the sponsorship of the company for a minimum of 2 years. They would need to have the skilled designation in their visa. And I think that's it. I'm just trying to think if there's anything
because
else.
I think there's been some confusion about total salary versus basic salary.
Yeah, so originally we were able to get approval with 30,000 dirhams as total salary, but they have become stricter on that recently, and it is now 30,000 dirhams basic salary.
Deborah's asking about UAE green visas. Is this if we have a self-employed person, can they apply for this and legally work for us in Abu Dhabi?
So we have had a couple of questions about green visas. Green visas is kind of a grey area still. We have looked into these previously. They do show in the system, but they are unable to be applied. We are waiting for that to open up and see if we can get some more information. And as soon as we do, we will be releasing an article or a blog post. But right now, we haven't been able to apply any.
And then I've got Roland asking here that if an employee is being transferred for a season outside of the UAE, but is still but still has a valid work permit in the UAE, should the employer reflect his salary to WPS, even if it's zero balance?
Um, bit of a more complicated one. Firstly, it would help to know for the period and duration of when the employee is transferring out for, um, because that will dictate them keeping their residency active. Secondly, it would the question there to you, Roland, would be whether this employee is going to continue working, if he's going to be paid a salary through a second or third party, what the situation is. I think the best case there would be for us to have a discussion after this webinar so we can understand that requirement a little bit better.
Batty is asking here, can a Dubai-based employee have a temporary work permit for Abu Dhabi? And can this be used to obtain CISPA passes for critical infrastructure in Abu Dhabi?
So a two-parter. Yes, a Dubai-based employee can have a temporary work permit in an Abu Dhabi company. That's not a problem. In terms of obtaining a CISPA pass, I would need to double check on that. So I'm happy to be reached out to directly. I would like to say yes. I know previously it wasn't possible, but obviously everything is starting to relax in terms of that. So it would depend on the relationship between the company that his visa is issued, the company that the temporary work permit is issued through, and whether that secondary company in Abu Dhabi have got the capacity to apply for CISPA passes. So it's a little bit more difficult to answer straight out, but possibly.
Elsa, I hope that I pronounced that correctly. Apologies if I butchered your name. When the leave is set for 22 working days, that amounts to 1.83 accruals per month, which is not legal. I mean, I guess that would be a reconfirm the legal allowance of annual leave for us.
Yeah, so the accrual is 2 days per month, is the accrual factor there. That's set by law.
Okay, I hope that answered your question. Thomas is asking, do you have any further details on changes in some free zones, such as TCOM, have introduced regarding golden visa applications? It seems that employees based in free zones can now only apply for a golden visa through the Free Zone Authority and the company portal. From what I've understood, they will no longer issue NOCs for employees to process a golden visa through channels like AMA Center. So obtaining a golden visa if you've been working for a free zone company is how I've understood that.
Yeah, so there was a change in terms of golden visa if you were under a free zone such as TCOM, that you needed an NOC that they had no objection to you applying for a golden visa. I'm unaware of this change that it now can only be done through the free zone portal. That is definitely news to me. It would surprised me that they were able to reroute the golden visa application through the portal when it's issued by immigration directly. But that's not to say that that isn't correct, but that's definitely not something that I've heard yet.
Rivera is asking about the new circular, about the public holidays based on cabinet resolution, so how that carries over.
Yeah, so with the public holidays, there are some limitations. Obviously, Eid holiday being one of them. That's one that the government might not change. The wording of the circular can be a bit confusing, but in essence, it is at the discretion of Mohri. If a holiday is following on a weekend, they can either give those public holiday days before the weekend or after the weekend. So it can be either on a Thursday and Friday, for example, if it's 3 days, or it can be on Monday and Tuesday in the following week. Again, it's at discretion of Mottery, and they will always publicly announce what those public holidays shall be.
Another question from Rivera. Is it possible to compensate overtime with lieu days and time in lieu instead of payment?
Yeah, so overtime hours can be provided with either the payout entitlement, or you can provide them with day off and leave.
Okay, another question from Roland. Will there be any implication if an employer cancels the medical insurance of the employee first before the work permit and visa?
Yes, the implications are essentially you should not have any employee working, or at least on the active work permit until for the duration that they don't have a medical insurance. So let's say, for example, you cancel their medical insurance, and then in 1 month later their visa will be cancelled. That is not advisable, because anything that happens to that employee, if they don't have coverage during that period, you could be potentially liable.
Okay, we've got a question here from George, which kind of sounds like if there's legal salary brackets. Is there a minimum salary requirement for a sales manager or a general manager in Abu Dhabi?
No.
Again, no, yeah, there's no minimum wage, minimum salaries, or a list anywhere in the UAE. The general rule of thumb is it should be a salary that's sustainable for the person to survive and live.
Daveen's asking here about, is it mandatory for me to provide accommodation for employees where the salary is between 1,500 and 1,800 dirhams?
Again, no, right? The breakdown of how that salary is presented, whether it's 100% basic or it's 60/40, whatever that may be, is completely up to the employer and their discretion to provide it. If the provision of accommodation is something the employer is comfortable doing on top of the basic salary, then by all means.
Revere is asking a question about an employee with a UAE visa doing short-term assignments in other GCC countries. What regulation would the employee then be, I guess, liable to in terms of overtime, public holidays, and stuff like that if they're doing a stint somewhere else in the GCC?
So, Faraz, sorry, if you don't mind me answering this, if you've got a UAE visa holder working for a company outside of the UAE, then they should have the relevant work permits in the GCC country that they are working in, and therefore you should follow the regulations of that country.
April was asking about how many leave days entitlement for an employee with 3 months in service. Is it just 2 days per month?
Yeah, 2 days is the equivalent of that.
2-day accrual. Anna's asking about when applying for a golden visa, free zone charges to a fee to provide NOC, which will be charged in the portal. Is the NOC chargeable only for the purpose of application of the golden visa? And is there a specific amount that they can charge?
This is quite similar to the previous one about TCOM. That's really at the discretion of the free zone. If the free zone have, if there's an agreement with the free zone and immigration, that immigration have to accept an NOC from the free zone, then it's really on the free zone to decide how much that they can charge. I don't believe that there is a bracket.
Joel's asking about designation. If you're going for the skilled category, does the designation have to say director to be able to apply for a golden visa?
Sorry, is director designation on visa compulsory? It will depend on the category. If you're going for a skilled a golden visa under the skilled category, then they don't necessarily have to have a director, but it does need to be a category 1 job designation.
Anna's asking a question here again about obtaining an NOC. does this have to be provided by, if they want to work part-time elsewhere, do they need to obtain an NOC from their current employer?
Yeah, so the free zone in the portal, you will apply through the portal for that NOC, and there are various different NOCs that you can apply for. So there will be one to allow one of your employees to work part-time.
Great. And then we've got time for one more question, and George has just got one here, which I think we kind of answered already, but can I obtain 2 visas, i.e. Dubai and Abu Dhabi simultaneously?
Hi, George. I feel like we've communicated a lot in the last 24 hours. No, you can't have 2 visas in the UAE. You can hold one visa in the UAE and multiple visas outside of the UAE. But in the UAE, if you have an Abu Dhabi visa, you cannot get a Dubai or a Sharjah or a Fujairah or a RAK visa. You can only have one visa in the UAE. You can have multiple work permits, but not multiple visas.
Okay, great. Libbie, Faraz, thank you so much for your time answering as many questions as we could get to in the hour. If anybody else has some pressing questions or questions that they'd like to ask Nina, Libbie, Faraz, or the rest of the team, please feel free to reach out to us. We're more than happy to help. We hope that you found this session to be informative, and we look forward to seeing you next time. Thank you so much.
Thank you
Bye,
very
everybody.
much, everyone. Cheers.
Thank you. Bye.
Bye.